Welcome everyone to today's webinar. My name's Connor Spencer, and today we'll be discussing funding and legal checklist for your business. So if you've not had this conversation yet with a lawyer, then this webinar is perfect for you. And if you're about to begin potentially a round of funding anytime between now within the new financial year looming within the next 6 months, then it pays to be proactive. So that when you obviously do need to pull the trigger, you have no stress or anxiety, and you're as prepared as humanly possible. So this is a very typical request for advice for our legal advice plan clients, whether that's just from having the right legal documents in place, getting advice on how you want to approach and negotiate with investors, or just having a roadmap in place early doors so that potential investors take you seriously. And that can be whether it's from family and friends, or you're scaling it large with venture funding, or looking at an employee share option plan in your business. This webinar is a good starting place to stay tuned as we'll be covering capital raising advice for you. And if you want to obviously take that conversation further with more tailored advice to your business, we do have an end of financial year offer live on our legal advice plan. So perfect time to max out your business budget for this financial year. It's fully tax deductible, so you can jump in from tomorrow with expert advice specific to your business. So I've launched a poll. So if you have 30 seconds to answer that, we'd really appreciate it, as your answers actually allow us to tailor future content to businesses just like yours, and also let us see what we want to perhaps introduce down the track to our advice plan. So another thing worth noting, if you do have any questions, please pop them in the Q&A chat and we will take them at the end. If we are unable to answer your questions, I'll loop in my email shortly so that we can get in touch if you're looking for any expert advice on a particular legal or accounting issue, or if you just need a run through of the LawPath platform itself. So today's webinar content will cover obviously a bit about LawPath. I'll introduce Molly here, who will be introducing today's topics. And Molly, we're covering everything there is to know about capital raising for your business. We can, as a small SME owner, navigate the legal and regulatory landscape. And she'll go through explaining about compliance and risk management. Now, Molly is one of our commercial and business lawyers that you can speak to on our legal advice plan. I'll provide the link in the chat where you can actually see all of our internal lawyers, but there you can actually see Molly's profile, where to list only a few topics. She has extensive experience in startup law, trademark law, e-commerce law, privacy law, and trust law. And if you do click on her profile, you'll see she actually has nothing but 5-star reviews from clients. I literally couldn't find a single review below 5 stars. And so I love to give credit where credit is due. If anyone would like to speak to Molly after this webinar, I'd encourage you to reach out. As you'll see from the reviews people are writing, she's very diligent, fast turnaround, and provides clear and concise advice, which is what you want. For those of you who are new to LawPath, so welcome. Comment below how you actually came to us. I know a lot of people actually refer to us by fellow entrepreneurs or by their accountants or business mentors, but many of you are perhaps finding us for the first time through Google or LinkedIn. So if you are finding us for the first time, we are an Australian-based online digital legal platform. We've been operating for 10 years now, and we've helped it's actually over 500,000 small and medium businesses now in different capacities within that time frame. We are built for startups who need legal and accounting services within a model that's far more economically viable than the traditional legal system. So within those 10 years, we've saved business over 100 million in legal fees, and we know this from the market price of what actually contracts take to draft. And we also know this through obviously the platform, through quotes, and we do actually have Australia's largest network of lawyers on our platform, and is used by more accountants than anywhere else. I think, in fact, there's about 8,000 of the 12,000 registered accountants in Australia actually use LawPath. And so if you actually had an accountant register your business, there's statistically a high probability that they use LawPath to register your company. But don't just hear it from me. I'll include shortly a link in the chat where you can watch quick video testimonials from our existing clients who may have businesses just like yours and are currently on our advice plan. So if you do join LawPath this June, after maybe 3 months of usage, we'd love to get your review and testimony as well. It's a bit of free marketing and exposure for your business. And of course, we would love to hear from you and your experience. But we have a lot to cover, so we'll jump right in. I'll hand things over to Molly.
Wonderful. There we go. I think you should be able to hear me now. Thank you, Connor, for that lovely review. Very flattering. But as Connor mentioned, I am a startup lawyer. I've been working with founders. I've got extensive experience working with founders and across the whole business life cycle. So whether that's setting up your new business and figuring out what the best structure is to set you up for success, all the contracts that come in between, like we'll be talking about today, raising capital, right through to founder exit. So I really enjoy working with founders and supporting people with their new businesses and hopefully making what can sometimes be a stressful time exciting. Awesome. So we have got a lot to cover today, and I think that it's always beneficial to, before you come into investment, and there's a lot of different options that you might look at, which we'll run through together. It's important to get your legals up to date. Seeking investment always takes a lot longer than perhaps people budget for. So I think that if anything that you can do to get on top of the investment process before you're going out to investors with your pitch deck or whatever it may be, I think that it's really important to sort of focus on that early part to make sure that if you miss something important at the early stage, you don't want that to hinder the process and the time it takes to get access to capital. So we'll go through later on in terms of the documents that would be required during investment. But at the moment, I think it's helpful to start with kind of some key things that you should be thinking about to make sure that your business is ready for investment. The first is that, and I'm assuming that a lot of people who are on this call, if you do have a business, that it would be set up as a proprietary limited. That's really important, and the reason for that is that there's limited liability for the shareholders, and it's a good vehicle for investors or your VCs, grants, all those incentives. You want to be set up as a proprietary limited. There is bells and whistles that you can go for, and perhaps some of you have heard of dual company structures, where you might have a holding company and an operating company, and we can absolutely go into the sort of ins and outs of those at Q&A if we have time, but otherwise I definitely recommend looking into that. We've got a lot of articles on the LawPath platform around dual structures, but the key takeaway from that is that it separates your value and your risk into two different entities, thereby making it more attractive to investors because they can feel that their investment is less risky. Once you've got your structure sorted, the number one thing that founders come to me with, often too late in the investment stage when they realize that the share structure isn't quite right for what they're looking to do. I've got extensive experience cleaning up these shares, but I think that if we can be proactive and try and get on top of that before seeking investment, it will put you in a really good position and prevent delays. We'll come back to the share allocation a little bit more further into the presentation, but just to keep that in the back of your mind. The next most important thing that you can be thinking about in getting your legals up to date is ensuring that all of your intellectual property is owned by your company. So some of you may be familiar with the laws in Australia, but the rule of thumb is that if someone creates intellectual property, so whether that's a software developer, someone's developing your website, someone's doing a bit of coding for you, unless there is a contract that specifically specifies what happens with the IP ownership, or that person is an employee of a company, the IP automatically vests with that person. And the problem with that is that if early on in these stages where you may be hiring a coder or you may be getting a friend to help you out with something, you really need to prioritize getting the IP vested in the company, especially because it can create problems for you down the track. And it's very easily done, and there's sort of two ways that we can deal with that. The first is always ensure whenever someone is creating something for you that there's some type of contract in place for the engagement. that contract will hopefully and should deal with the intellectual property ownership within that relationship. So for example, if you have a software developer, engaging them on a contractor agreement where it specifically says that anything that they create for your business is vested in your business. The same goes for founders as well, especially for businesses that might have started as a bit of a side hustle, and maybe you were working on it for 6 months, 12 months before you decided to register a company. In that situation, technically the founders individually own the intellectual property that's been created. So we just need to make sure that that intellectual property moves to the company. Easily done, and we have plenty of these resources on the LawPath platform, but in that instance, you need to sign some kind of documentation, such as an assignment of intellectual property deed, where basically you sign off and vest the intellectual property into the company. This is one of the number one things that investors will be looking at when they're doing their due diligence. And it can also be a risk area as well. I've heard plenty of horror stories of particularly when perhaps you started your business and there was 3 co-founders, you were all working on the intellectual property together, and early on one co-founder decided to resign and didn't want to be involved in the business anymore. The issue then becomes that unless that intellectual property is moved to the company, and like I said, it's an easy enough process, it's just something to be aware of, then you might have problems later down the track where, say your company is now worth $100 million and you've got this co-founder knocking on your door asking for their entitlements, because technically they would be correct that they still own part of that IP. So not to overwhelm you, but my takeaway in terms of intellectual property is that anytime that someone is developing or creating or having access to your intellectual property, we need to make sure that there's a contract in place, whether it's a contractor agreement, software developer agreement, whichever it is, that deals with IP. And for pre-existing engagements where perhaps that you didn't do that, we want to assign the IP over to the company in an IP assignment deed. Cool. So, and today I should mention as well that I'll predominantly be speaking about raising funds as a private company in Australia. I imagine that a lot of you, if you do have companies set up, will be private companies. And absolutely happy to talk about fundraising for public companies, but it could definitely be its own webinar. I guess the key takeaway is that public companies are highly regulated and have burdensome financial reporting obligations as opposed to a private company. So typically we try, and of course there's scenarios that it would be appropriate, but if, depending on your situation, often private companies are trying to stay as a private company to avoid those obligations. And we'll go through those in a little bit more detail shortly. The key thing to think about when raising funds as a private company is that there is a limit of 50 shareholders that you can have in your company before you must transition to a public company. And like I said, and we'll speak about the documents that are required for a public company in a moment, but the preparing these documents is a burdensome and expensive task. And unless required, we should be aiming to avoid that process. And often startup businesses that are raising capital, especially for the first time, are looking to avoid that. The key thing to think about in ensuring that you don't have to go through that process and you don't have these additional obligations is, again, keeping your shareholders at no more than 50. That's an important consideration and something that we'll talk about a little bit more dilution. But a number one problem that I see, especially for early stage businesses, is getting a bit excited about raising money, perhaps a little bit desperate. We're running out of money in the bank account, and perhaps giving away either too high percentage of their company, which we'll discuss soon, or giving away to too many shareholders. Because if you think about the beyond just now of needing cash in the bank, and you consider, the growth plan for the next 5-10 years, whatever it is for your business, over the years, you might have various rounds of funding with different investors. You might have friends and family come on board. You might bring on a co-founder. You might issue shares to advisors, and keeping that in the back of your mind so that you don't give away too many shares too early and find yourself hitting that 50 shareholder limit. And the other thing to think about as well with fundraising as a private company is, as you can see here on the slide, there are strict conditions for raising money as a private company. You might have heard of the 2012 rule, and basically that the rule of thumb for raising capital as a private company in Australia is that you can raise up to $2 million with 20 investors in a 12-month period. There's exceptions to that, which we'll go through, but just keeping that in the back of your mind and being aware of this obligation. The key thing of raising capital as a private company and around these limits that are provided under the Corporations Act is that you can't advertise your raising publicly. So there's particular people in the circumstance of private company, and you'll be familiar with this process, I believe, in that typically private companies go to family, friends, or someone with a professional connection. Otherwise, you'll be looking at sophisticated investors, and that might be, you know, accelerator programs, VCs, and the typical fundraising trajectory that you hear of. The reason for this is that there are certain exceptions under the Corporations Act for private companies raising capital. And for those sophisticated investors in your VCs and your accelerators, the reason that they are perhaps more accessible to private companies is because there are less protections under the Corporations Act for them compared to, say, your mum and dad investor, meaning that burdensome paperwork and the financial reporting and things that might be required otherwise are not required for these types of investors. So it means that you have access to capital, and particularly possibly investors that maybe have a good name that you can you know, bounce off their reputation as well, and sort of get out of having those additional reporting requirements. Cool. So as I mentioned, the disclosure documents required, which basically, I'll go to the next slide here. So there's 4 types of disclosure documents, and these are the documents that I referred to that public companies are obligated to prepare. So if you wanted, and this is why we sort of, as private companies, might rely on those people with a personal connection, a professional connection, or a sophisticated investor, because with those people under the exception, we don't need to prepare these documents. So these documents, I'm sure you would have seen in the public sphere as well, and they're publicly available for public companies. And it's a very, like I mentioned, expensive and burdensome process to go through to prepare these, and also ongoing management of keeping these up to date, and whether it's an annual requirement or whichever it may be. So it's kind of this reason that we sort of aim towards those personal connections, professional connections, and sophisticated investors for raising capital as a private company. Cool. So in terms of deciding, I guess that's a high level on the sort of rules and regulations that you need to keep in mind for deciding about raising capital. And now I guess it's the kind of the number one question that we get is how do I raise capital? What's the best vehicle to use for my fundraising? And there's a number of things that we will run through together on what might be best. But I'm sure that you would be, you know, we've got priced equity rounds. So whether you're doing your pre-seed round, your seed round, you're selling shares for money. Otherwise, there's other things that you might have heard about, such as a safe note, a simple agreement for equity, or a convertible note as well, a couple of different options. And when you're deciding on what the best method to use for you as your business, there's a number of things that you might consider. So in terms of deciding the best method, there is a whole range of things that you can think about, but to sort of give a bit of a guide, some of the ideas that we have here is thinking about, have you raised external capital before? Is this your second raise? Is this your first time going to investors to seek capital? Have you spent quantifiable resources on your business so far? have you invested $50,000 in a website? Have you brought $100,000 worth of product? Or perhaps you're a software developer and you've spent 1,000 hours chipping away at your work. All of these qualifiable resources and hours spent can start to show value in your business, as well as if you're pre-revenue or if you are post-revenue, if you've got letters of intent. Sometimes big commercial businesses will offer a letter of intent saying, yep, we really love your idea. Once you seek capital, we're on board. Things like that can be helpful for the type of investors that you might approach and the avenues that might be available for you. Same as R&D tax incentives, and also what you have to lose at the moment. So, and we'll cover that more. And I've already touched on it a little bit about dilution and making sure that you retain those shares. But that's also an important thing that we need to keep in mind. And investors, particularly for early stage businesses, are typically investing in the founders. The idea, sure, but it's the founders that have got that drive, that energy, and it's the founders that they believe are going to make a return on investment for them. So making sure that the founders are involved in the company, and there's a number of ways that they will ask for protections for that, such as founder vesting, but we can jump into that shortly. So generally speaking, and this is very generally speaking, because like I say, there's a lot of considerations that come into it, such as the investors that you have on board, what your negotiating power is, what market you're in, a whole bunch of different things. But this is just a kind of general guide on what sort of instruments you might decide to use. So the first is that, you're pre-revenue, you maybe have little to no evidence of your resources spent. So, you haven't invested a lot in this company. It's sort of just at that idea stage. And at this point, you would naturally struggle to have a valuation for the company. And you wouldn't necessarily know, you need money and to continue with your idea. You're really passionate about it, but you wouldn't be able to value the company right now. And the risk of creating a valuation too early is that more often than not, you'll probably underestimate the valuation and you'll have to pay for that later. So typically for this stage, we recommend a simple agreement for equity, a safe note. And I've got some slides coming up on the way that would work. But basically, a safe is a way for early investors to get on board. It's a higher risk because, you're pre-revenue, you've got little evidence. It's often family and friends that come on at this rate. They want to give you money, you need money, and the deal is basically that money will convert into shares at a later point as agreed by the parties. And yeah, like I say, we'll come back to safe notes. And then in terms of that sort of second group that we've got here, this is sort of pre-revenue. Maybe you've got stronger evidence of the resources that you've spent. You might have some previous external investors, again, perhaps not a set valuation. And here and I will caveat this, that it's not always, and more often than not for founders, it's not the best avenue, but you might consider a convertible note at this sort of stage. I would still personally, from a founder's perspective, safes are the way to go, because the difference between a safe and a convertible note is a debt instrument. So, and we'll come back to that as well. But essentially, under a safe, you're agreeing that investment will convert to shares at a future point. Under a convertible note, you're agreeing that at a set maturity date, at the investor's discretion, that money will either convert into shares or will need to be paid back to the investor. And the risk here, of course, it gives the investor more security and flexibility. It might be preferable to investors. But from a founder perspective, the risk here is that, say you have an investor come on with a convertible note for $100,000 and it's got a 24-month maturity date. So in 24 months' time, the investor can decide whether they want that sum to convert into shares or to be paid back. And at any point, perhaps their investment appetite has just changed, and it might not necessarily even be a reflection of your startup. They might decide at that 20-month period to ask for the debt to be paid back subject to interest. The problem that startups, especially more early stage startups, will face at that point is that you would have spent this $100,000 in the last 2 years, and then perhaps your access to capital to pay that back is limited. And you might find yourself in an issue where you owe money larger than what you can afford to pay back, in other terms, insolvent trading. And your avenues at this stage as well, if you have a convertible note and the investors opted for it to be paid back and perhaps you don't have access to that capital, your options to access other avenues of capital might be restricted as well. So if you're unable to pay it back, you might not be in the position to apply for a loan or any other debt instrument to pay back that money. And whilst you might be able to, you might have connections with other investors, and perhaps you go for you approach a different investor for, or whoever it is, for an injection of capital. The problem that you'll face there is that almost never will investors be comfortable with their money being used to pay back debt. They want to invest in the growth of the company. They don't want to invest to pay back existing debts. So you might find yourself in a really tricky position where you can't afford to pay back this convertible note, which, if it was under a safe note, you wouldn't find yourself in that position whereby you wouldn't be paying your safe note back. And like I say, we'll come back to convertible notes soon. And then in terms of our last sort of category that we've described there is it's a business that's generating revenue, resources are expended, maybe there's probably some previous investment that's happened, a more set valuation on what the company's worth is the key part here. And perhaps you're considering issuing new shares, so having a priced equity round at that point. Or debt instruments as well. But in terms of having that priced equity round, you've got the set valuation, you know what the shares are worth, and then you are issuing shares to the investors at that rate. And we'll talk a little bit about allocating shares in a moment. So whether you are entering into a safe note, a convertible note, you're issuing shares, maybe you're issuing options to your employees under an ESOP, the most important thing that you can have internally is a capitalization table or a cap table. It's essentially just a glorified Excel spreadsheet where you keep track of the ownership of the company and you use it for scenario modeling. So it's really important. And when I spoke about founder dilution earlier and making sure that you don't get too excited early on and issue too many shares up front, or maybe bring on too many investors, having a capital table with modeled scenarios will help you to make more informed decisions on what it could mean for you in the future. There's plenty of capital tables that you can access online as templates. Otherwise you can speak to your lawyer or accountant to prepare a bespoke capital table for you to use, which you can continue to use yourself after the initial spreadsheet setup. Or there's plenty of different ways that you can manage your cap table, but the number one thing is that you do have one. So to give an example of how that might work is that, say it's just you and your co-founder at the moment, you're looking at raising capital, you think you're going to do a priced equity round, you might have an advisor that comes on later down the track that you're not sure how much percent you want to give them. At the start of your cap table, your 50-50 shareholders with your co-founder, say you both own 100 shares each, there's 200 shares in the company. And then you think, okay, and for easy numbers' sake, because I'm a lawyer, not a mathematician, so perhaps there's an investor that you're thinking of coming on board and they want to be a 1/3 shareholder, so 33.3% each. So in this case, what you would do is you would model and you'd say, okay, me and my co-founder own 100 out of 200 shares each, we're 50% owners. And then what would happen if we issued 100 shares to this new investor? Now you all own 100 shares out of 300 shares, so you can see that you're a 33.3% shareholder. The important reason that you need to keep track of this is that each stage that you do these, perhaps you do a bridging round where you just seek a small amount of capital from an investor, or a previous investor tops up their investment to get you through to the next capital raising round, or whatever it might be. You can see that without sort of having a clear idea of what that will look like for your dilution, you can end up in the position where the founders own significantly less percent of the company than was intended. And the problem with that is that if you've worked so hard to get the company to where it is, And, if, for example, if you need to do a bridging round where an existing investor tops up a little bit of money because you need that $10,000 to get to the next stage, otherwise, you can't continue. You're in this hard position where you have no choice but to go ahead with that. And then now, you're continuing to get diluted. And that is an issue for a number of reasons, but mainly you've set up this company, unless that was your intention, to become eventually smaller shareholder, you're losing your rights and responsibilities and control that you have over the company. And you might also hinder future investment. As we discussed before, often investors are investing in you as founders. And if you've got, throughout all these processes of capital raising, whichever, if you've got yourself down to 30% shareholders of the company, investors might start to ask, is that enough percent does that founder own enough of this company for them to have the drive to get out of bed in the morning and make a return on my investment? And the problem is that once you get too far down and you realize that you've issued too many shares or whatever it may be, it's a tricky position to get yourself back into that higher threshold. So having a cap table means that you can model that out and you can explore different options and what it's going to look like. You can keep track of making sure that you don't have more than 50 shareholders. You can allocate, in the future, you want to set up an employee share option plan, so you can see what that might look like and how that might dilute you further down the track. Wonderful. So in terms of, I said we'd come back to a safe or a simple agreement for future equity. Basically, the concept of a safe note is that, like I said before, you need money. You've got someone, maybe your family or friends, that are willing to invest money in the company. They don't care about having control over the company. They want to support you and get a return on their investment later down the track. They're confident that you're going to make it. They're happy to give you this money. And then you can take that money, spend it as you need. And then at a future point, this investor's hoping to get that return on their investment. The way that they work is that because you have no valuation, you basically are agreeing that, for example, a friend says, I want to invest $100,000 in your business. And you say, okay, well, I don't know what my company's worth, but I am planning on, raising capital in the next 2 years. And the way that we would set up the safe is that, and this would be the incentive for this early stage investor, is that you would say, I don't know what the valuation is going to be at this future investment round, but when this investment round happens, or this qualifying finance round, I'm going to offer you a discount on the price of shares. So in practice, your family friend, whoever it is, the safe note holder, invests $100,000 in your company. In the agreement, you say that at a qualifying financing round, a future capital raising round, then the $100,000 investment will convert into shares. That will be at, for example, a 20% discount rate. So what that would look like is that if in the future you raise money at a $1 million evaluation, with the 20% discount applied, this early investor that took a risk on you will pay for their share price at an $800,000 valuation. So they took a risk, and it is a riskier document because there is no guarantee to be paid back like a convertible note. But then they have the opportunity to get a higher return on investment. Cool. So yeah, this is basically just explaining what I went through about you're taking cash for investment, offering shares at a future date. And because there isn't a maturity date like a convertible note, in practice, what often happens is that the shares are either converted at this future event or the safe note is never paid back. More and more we're seeing that the current safe notes that are available, there's plenty online. We have one on LawPath as well. And we're starting to see more of a push for automatic conversion. So that would mean that basically if the capital raising or qualifying finance round doesn't occur at a set date, you would agree on a valuation, say, okay, it's been 3 years, there hasn't been a qualifying finance, but this investment amount is going to convert based on fair market value, whatever it may be, up to a certain amount. And that just gives the investor a little bit more security. But it still doesn't have the obligations on the business to pay back that amount, because it's still just converting into shares into the company. Cool. So yeah, explaining there at point 3 about the qualifying finance round and at the conversion rate with the discount applied. So these early investors do get a better deal. Wonderful. Cool. So I think I've covered off on convertible notes earlier about sort of the risk profile for founders and startups, and naturally by virtue of having that right to be paid back, it is more attractive to investors. But you want to be really sure if you're entering a convertible note as a founder or startup. Just making sure that you're comfortable and aware of that risk that you might need to pay back this debt instrument. And there's also more things to sort of be aware of internally, such as keeping track of maturity dates and other things like that. So there's definitely a time and place for convertible notes, but I would be hesitant before entering one, and just really making sure, speaking to your lawyer or your accountant, and making sure that it's a good option for you, and that your business could cope or manage with the potential of having to pay that convertible note back at the maturity date. Cool. So moving on to allocating new shares. I mentioned right at the start about getting that your share structure and your share capital right from the beginning, so that we don't have to have any delays when we're sort of bringing on new investors at capital raising. And keeping in mind that once you get to the point of term sheet signed, shareholders agreement, subscription agreement, we want to move quickly, and we don't have time to deal with the delays with ASIC to update any mistakes that we've made in allocating shares. There's the two key things that I say to founders when they're starting to think about raising money is I want to ask how much shares they have on issue and what the share price is. It's really important that there's a high number of shares on issue. When I meet founders, and it happens all the time, maybe you issued 100 shares, 50 shares each, or even maybe you had 10 shares each worth $1. In terms of the number of shares, we'll come back to the price in a second. The higher number of shares that you can get early on, allocating to yourself, maybe co-founders have 500,000 shares each. It's important that we can keep that number high, because when we get to that cap table modeling scenario, you can only issue shares in whole numbers on ASIC. You can't have less than a whole number. So if we're starting to deal with smaller numbers, such as 100 shares, and you're issuing 100 shares in a capital raising, and then maybe 1 share to someone else and 10 shares to someone else, it can become really hard to manage, and you'll probably end up in a situation, because of this whole number limitation, where you don't have the right amount of shares to appropriately distribute as you intended, in which case you would have to go down the process of doing what's called a share split with ASIC. If anyone has any experience with ASIC, you'll know that it can be a complicated and long, timely process. And share splits in particular are still you can't process those online. So ASIC still requires that you send paper lodgements for those. And basically what would happen is, if you got to this point where you realize you didn't have enough shares on issue, you had maybe 10 shareholders, you wanted to bring on someone new, and you realize, we need more numbers. What you would then do is you would need all the shareholders to sign off that their each shareholding portion would multiply by whichever number to increase the amount of shares on issue. It won't affect the value of each shareholder's shares, but it's just a long process that can really get in the way. So when it's just you and your co-founder, or early on, it's the higher number of shares you can have on issue that you're going to be set up for success, and your cap table management is going to be easier. In terms of share price, you can issue shares down to 4 decimal points on ASIC. So you can have it as 0.00001 cent on per share. So, and of course, we want to have, at that initial stage, when you're setting up your company, or you're pre-revenue, you haven't sought any investment. If we can get a high number of shares at that low share price, then that's our perfect medium. Because the issue that we run into with private companies is that the great thing about them is that the shareholders' liability is limited to the amount that their shares are worth. So that means that you have this element of protecting your personal assets from your commercial liabilities. However, if you followed and issued 500,000 shares to each founder, you were like, yeah, we want to keep the cap table easily managed, a high number of shares, but you issued those at $1 per share, then actually you would owe the company each $500,000, And if you ever were sued or creditors went ahead with like a liquidation or winding up application, then each co-founder would be liable for that amount of 500,000. So if you have done that and you've issued a really high number of high value shares early on, it can absolutely be fixed. So don't stress, but it does need to be fixed. And I would highly recommend speaking to a lawyer, myself, whoever, or an accountant to go through that process with you to fix that up. Cool. Awesome. So in terms of allocating new shares under a safe note or con note, that would be only at the time that the conversion event happened. So for a safe note, perhaps qualifying financing round, that safe note holders issued new shares. And again, you would want to keep track of that kind of thing on your cap table. You need to know in the back of your mind that you've got this liability where the safe note holder is potentially going to be issued new shares and therefore founder dilution. With a convertible note, similar thing. If it gets to the maturity date and the investor wants to convert the investment into shares, then at that point they would be issued new shares. Otherwise, in terms of a priced equity round, this will typically, in certain sophisticated situations, you might do a share transfer, but as a rule of thumb, they're going to be being issued new shares in the company. So the documents that you would require for going through this priced equity round would making sure that you've got your company constitution, your shareholders agreement, and your subscription agreement or an application form. So I'll go through these a little bit more detail. So if you've set up a company and you used LawPath or your accountant or someone that's a professional that provided you with template documents, you more than likely were given a company constitution, which you would have adopted at that early stage when you signed your initial registration paperwork. If you don't have a constitution, the Corporations Act has a set of replaceable rules which apply for your company. So it's not compulsory, but if you want to vary or change from the replaceable rules set out in the Corporations Act, then you would adopt a company constitution. The company constitution is more of a procedural sort of document, and it sets out things such as how many directors, if there's a minimum amount that are required, how board meetings go ahead, what quorum might be for shareholder meetings or director meetings. It's largely a procedural document. And typically, if you then in your shareholders agreement, in some ways covers some of the same things, but a little bit less procedural. So you would adopt a shareholders agreement, ideally the moment that there's more than one shareholder, so between you and your co-founder, because this sets out the rights and the responsibilities of each of the parties, as well as how the company's run. But if you don't have it, and ideally, again, you should, even just between yourself and your co-founder, but certainly at the time that you're bringing on investors, you'll need to adopt a more sophisticated shareholders agreement. And the way that usually works is that the shareholders agreement will prevail over the company constitution, but these two documents work together to set out the rule book of how your company's run. Your constitution will also contain what kind of rights are attached to the shares that are on issue or what shares can be issued. So whether that's dealing with voting or access to dividends or whether it's ordinary preference shares, that will all be included in your constitution. Oh. And then, like I say, your shareholders agreement deals more specifically with things such as, founder rights, perhaps founder protections. It might separate identify what decisions require what percent of a vote to pass, and this would be also where I mentioned that share vesting might come into play. So when I speak about share vesting, we can use that for a number of different things, but in terms of seeking investment, likely, especially at these early stages, if you're seeking investment from an investor and say there's two of you co-founders, again, they're really excited by the two of you. They love the idea, but you haven't got a lot to show for it yet. They're really investing in your drive, your energy. So for them, it would be a risk if they invest in this company and then for whatever reason you decided to resign or not be involved. So the way that they can protect against this risk is to require founder vesting. So what this would look like is that a typical vesting period might be 4 years, made up of a 12-month cliff, So that means that for the first 1 year of the investors coming on, you don't own your shares, and the company has the right to buy them back for a nominal amount if you leave in that 1 year. After that 1 year, then you start earning the percent that would be set out over that 3 years. And it's usually, periodically, maybe it's 33% per year, or maybe it's on a monthly basis, whatever it is. And that essentially forms what you would have heard of sweat equity. So it's ensuring that the founders stay in the company and they're working for their shares. So that's a protection that investors will often negotiate to have in your shareholders agreement. The other thing for founders that you can use your shareholders agreement for is to include specific provisions that might protect your rights and responsibilities as founders. So making sure that, for instance, you might require for quorum for a meeting of the shareholders, that one of the founders must be present. And we can just include additional rights like that to ensure that whilst you are going through the stage of bringing on other shareholders and perhaps your shares are getting diluted, there's these additional protections that you have to make sure that you can retain control of the business. Cool. And then this is, again, for if you're raising capital from a price equity round, you'll either have a subscription agreement or an application for shares that will go alongside that shareholders agreement. So the shareholders agreement will manage the rules, the rights and responsibilities of shareholders. And then the subscription agreement, or the application form, is basically the new investors agreeing to pay money into the company and agreeing that they will become party to the shareholders agreement. Cool. Wonderful. I'm just mindful of time, but in terms of debt instruments, I think that typically, and this is sort of the final point of fundraising that we haven't really touched on yet, is that I think there's often this kind of perhaps hesitation to enter debt instruments, and maybe a more preference towards price equity or bringing on these investors. But I guess I would love to encourage you to consider all of the options each time, as sometimes a debt instrument might be more appropriate for your business. Particularly around retaining control and things such as we discussed about founder dilution. Is it worth diluting your shares to have an investor invest a small amount of money, or would it be preferential to just go down a debt instrument option, retain your dilution, and then raise capital at a later point where the shares are worth more and you're giving away less shares for more money? Cool. So in terms of debt instruments, you absolutely want to speak to your accountant and lawyer about this and what suits your specific situation. But normally a debt instrument will comprise of a letter of offer, some kind of loan agreement, maybe a general security deed, and possibly a personal guarantee by the founders as well. So where a Personal Property Securities Act registration is required under the instrument, the loan instrument, it's basically the immediate right to appoint a receiver in situations where there's a default under the loan. So there are these obligations that you absolutely want to be aware of, comfortable with, and completely understand. I would really warn against signing into the debt instruments that you haven't had a lawyer read over for you. Another thing to keep in mind as well is that if there's no due date, the general law is that it's due on demand for payment. Again, something to keep in mind, but I really encourage that you wouldn't sign a debt instrument without speaking to your lawyer. And then on here on point 4, if a company enters into a debt agreement, there should be a reasonable basis for the company to repay that loan. The issue that you face there, and we sort of touched on insolvent trading earlier, is that there's certain regulations and obligations on the directors of companies in which they can actually be held criminally liable. It's not something to be afraid of, but it's certainly something to be aware of when you're a director of a company. There's plenty of articles on the Law Path website setting out what those sort of obligations are. But if the company is found to be insolvent trading, so entering debt instruments that they can't pay back, entering a convertible loan that they can't pay back, then the directors can be found personally liable for insolvent trading. So it's certainly something to take seriously and speak to your lawyer about. And other instruments that you might look at is, R&D funding, trade finance, and government guaranteed loans as well. Cool. So we've covered a lot of information today, and there's a lot that we've gone over, and I think that it's important to sort of think about the key stages of your investment process. So before you even, you're thinking, we're going to need capital at some stage, we're not sure what path we're going to go down, making sure that you've got those initial steps that we covered set up is going to benefit you in the long run, whatever route you go down. Making sure that you've set up your company in the correct structure, making sure that you've allocated the correct amount of shares early on, and that you haven't unintentionally increased the share price and therefore the shareholders' liability. Making sure that you've got all the appropriate contracts in place. So not just for dealing with intellectual property, but also for, perhaps you're in a manufacturing agreement or you are entering client agreements. You need to make sure that any time that there's any risk or value that's being created or caused, contracts are in place. Making sure that all of the founders have signed IP assignment deeds to make sure that the intellectual property is owned by the company. Checking these things are really important, no matter what path you go down. As I alluded before as well, considering having a shareholders agreement for just the founders at that early stage. Eventually, if you have investors come on at a price equity round, more than likely is going to be negotiated and the investors might ask for additional rights, but having that initial document that governs your relationship with your co-founders is a massive protection that you can put in place for your company. And it can also prevent further disputes down the track. Sitting down and agreeing on terms of how your company will be run means that if something goes a little bit wrong later on, you've already got this rule book that you've all agreed to and you can follow procedure there. Cool. And so considering as well about, what is the best option for you, whether that's a safe note, whether it's a convertible note, priced equity round, debt instruments, whether you're applying for funding, just keeping in the back of your mind all the time about founder dilution. We need to have some kind of game plan to make sure that, if that is the intention, you retain control over your company, and considering what that might look like. And when things like convertible notes or debt instruments, making sure that you do have the means to pay back that debt if that should be required. In terms of fundraising, if we're going for a price equity round, keeping in mind those rules that are set out in the Corporations Act. We're not like a public company. We can't publicly advertise that we're raising funds. It needs to be from a personal connection. So your mum, your dad, your sister, your neighbour. A professional connection, maybe you work with a high net worth individual or someone who's really interested in investing in tech startups, or you go down that sophisticated investor route where that could be high net worths or VCs, accelerator programs like that. Cool. And in terms of, so once we've considered that, we're just how LawPath can help as well. I think, I'm not sure, Connor, whether, no, cool. I'll give a little bit of information there, but I'm sure Connor can help as well. But yeah, like I mentioned at the start, I specialize in capital raising events, and there's a lot that needs to be considered, and it can definitely be overwhelming for founders going through that process. So making sure that you feel comfortable that that initial stage of those documents that we discussed, IP protection and ownership is all dealt with early on, making sure your share structure is correct, and all of these documents that I've discussed and brought up today, whether it's a safe note, convertible note, whether any process, any point of the investment round, they're all available on LawPath platform. And Connor will take us through shortly in terms of how that might look. Cool. So I guess, yeah, in summary, don't be scared. It's an exciting time, but there certainly is a lot to consider. And I think that earlier on that you can make sure that you're getting your legal documents prepared, you're getting your structure correct, you're really considering what this, your capital raising event might look like for future dilution, then you're in a great position, and then we're happy to help.
Awesome. Thank you, Molly. I hope everyone found that informative, and it really is a huge topic. It's actually quite a lot to get through, a lot of nuances. The last time we actually ran this topic, it went on for 75 minutes, and we had a lot of people post-webinar engaging with us because they had more questions around certain slides, or questions obviously around capital raising that they were about to do. These slides I'll get shared out, and the video will go on our YouTube page for those of you asking. But the gold standard would be to speak to a lawyer to engage with us directly. As Molly was pointing out there as well. So we'll take Q&A questions shortly. So if you have a question, please type it in for Molly to answer within the next 5 minutes. I've launched another poll for feedback. So if you guys would obviously like to see anything going forward, please give us some answers there. And if anyone else has any question, maybe outside of the topics we've covered today, at the start of the webinar, I mentioned a few of the things that Molly's also an expert in. So if you have any other legal questions, feel free to pop them in the Q&A chat there, and I'm sure she'll be happy to answer. But general rule of thumb is, look, if you have a business or commercial legal need, we can assist in some capacity one way or the other. But if you are running a business, your day is probably currently operations, it's sales, it's marketing, and that's predominantly what you're focusing on. But you're aware, obviously, you need to cover yourself legally, and you have some gaps potentially in your own legal knowledge. It's probably why you're here on this webinar. Perhaps you're looking for some taxation and accounting advice to save your business money in the long run, or maybe you're looking actually for that competitive advantage amongst your competitors, or you're simply just looking for contracts and agreements at this stage. So that's where we come in. We support small, medium businesses in a myriad of ways. We provide on-demand legal assistance through the software and our contract management system. We have a built-in e-sign feature, so you can sign, save, and send out your contracts electronically. And if you didn't know, we're a tech company just as much as we're a law firm. So if you're wondering why at times our costs are so low by comparison to other lawyers and accountants, it's in large part because of the technology. So as soon as you introduce something online or with software, because of its convenience, because it's software, it immediately lowers the cost. Just look, for example, within the last year, what AI is doing for small businesses. We now have like daily calendars which incorporate AI, MyOb and Zero, which are accounting softwares, integrates AI. And we at LawPath also, funnily enough, incorporate AI now. And some of the top features on there is there's an Ask Me feature for quick questions outside of business hours. And I say outside of business hours because if you have access to lawyers, you also have a live chat and next day consultations. There's a Draft Me feature, which we actually have lawyers who have no affiliation to LawPath using that within their own contracts for clients. And there's also a review feature, which provides some simple insights to your documents. We do possess over 500 legal documents in our library. These are all up to date with Australian legislation, and they've already been drafted by a team of commercial lawyers. We do update them as and when changes do get made, especially around employment. And all you have to do is follow the step-by-step to fill in the relevant clauses. But if you do wish to click into the document, you can add or remove provisions to customize it further. That being said, most users do not have a legal background. So if you are going to be signing any agreement, you'll want to make sure you're 100% informed as what you're agreeing to, not 50%, not 99%, but 100%. You need to understand your own documents or documents maybe you're actually being provided with by someone else, because we do review external documents as well. You may need to include clauses around non-solicitation, non-compete, and maybe need to add in terms to protect your business from an IP standpoint, or you need to grab an NDA. Or you just simply need some workplace policies to protect yourself from a potential disgruntled employee. So you would have hopefully seen I've included links in the chat where you can actually read some of the other hot topics we discuss. These are not limited to, these are just some of the big ones we do discuss on the advice plans. But they're often around business structuring, business purchase and sell, employment and HR advice, IP, debt recovery, and commercial property law. And what we're trying to do is obviously provide the best of both worlds through the platform. So most business owners, when they think of getting legal or accounting advice, they think high cost and long wait times, and sometimes they'd be right. Senior lawyers typically charge around $600 for an hour's consultation, accountants around the 150, 200 mark. But you don't need to. So we have that one-stop shop where you can get unlimited legal advice, unlimited on-call contract reviews through the platform without costing you an arm and a leg. There will, of course, sometimes be instances where you require hands-on legal work. That can be registering a trust, registering a trademark, something that Molly has experience in, or rather, you need maybe the lawyer to go away and draft a contract complete from scratch. Maybe we already have on the platform, but you'd rather just they did the legwork for you. And one of the benefits of being subscribed to LawPath is you do get discounted fixed price quotes for any of that additional legal work. All right, so I've actually in the last week heard from people who have now joined the LawPath platform. Ricardo, if you're on the webinar, please feel free to say hi. He was charged about $5,000 for an employment contract review. I've also heard within the last week a business sale lawyer was billing around 7K. We've dispensed with that. It's all about out with the old model, in with the new. Otherwise, you may want to actually look at also our most comprehensive package, the legal and accounting advice plan. You get also unlimited consultations with our award-winning chartered accountants, and our lawyers and accountants do liaison with each other. So perfect if you want to optimize and streamline your legal and accounting by having it under one roof. Again, I've provided a link in that chat where you can read some of the hot topics on the accounting side. But generally, what everyone wants to know is, and what people have listed in the poll is, understanding specific types of tax around GST, PAYG, crypto tax, and capital gains tax. But the real big pull is advice around tax minimization strategies and tax concessions that they want to know if they're eligible for, and obviously what they can claim as tax deductibles, just to help every small business owner make smarter financial decisions. They'll also provide advice around restructuring or business structuring advice. It's more tax focused when you're speaking to the accountants in regards to that. They'll also provide advice on reporting payroll, bookkeeping, and a host of other topics. So you can hopefully see from the screen there, there's the ability to add on the tax compliance. And all that means is just that hands-on work for you. So it's your BAS lodgements, tax lodgements, and financial statements. And while you do already have unlimited consultations with the accountants, you do actually get a special fiscal year consultation to do a deeper dive and analysis of your business spending and revenue. Everyone will be pleased to hear, if we just go to the next slide. Sorry. That one. We do have a 30% lifetime discount with that subscription. So if anyone would like to claim that, or you want a demo, or you just want some more information, please type yes in the chat, or feel free to email me directly. I've provided my email in the chat there as well.